Okay, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, I will let you know whether or not I've determined probable cause, and then we will talk about release conditions. I want to let you know that today is not your trial date, so I advise you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by attorneys from the Public Defender's Office, I do have Attorney Brian Reedy in the courtroom with me. And over at the main jail, you have Attorney Hector Romero. You can speak with those attorneys before you attempt to speak on the record. Also, if you have a private attorney, the private attorneys come to the courtroom and they'll be able to speak to me or address me or speak on your behalf. You also need to know that in the courtroom, we do have an attorney from the state attorney's office, Mr. Eric Linder. I also have confinement status, and I have pretrial supervision in the courtroom. We also have the clerk of courts who maintain the records here. And so when I call your name, you will be directed to stand at the podium, and then I will address everyone individually, okay? So this morning, we will begin with Carlette Irvin.
Danica Carr on behalf of the city of Fort Lauderdale.
Good
How are you?
morning. How are you?
I'm great, thank you, Your Honor. I am going to be asking to be appointed to her case, but I did just speak to the jail based on what's going on medically. So I'm asking to be appointed, and I will also be here. I cover the weekends, so I'll be able to follow up with her and see how she's
Or where is Miss Irving?
at North Broward, but she's not actually there.
She's not
She's a
there?
medical reset.
She's a
so-
medical reset. Okay,
But I'd
so
like to be
we'll
able to
reset.
take care of her tomorrow too. So if that's
Okay.
is that okay?
That's fine. I'll reset it till tomorrow.
Thank you.
All right, Zakendra Gary.
Same, Your Honor, also at North Broward, but a medical reset, still asking to be appointed, and I'll check in
Okay, so
tomorrow.
we'll reset that also for tomorrow.
Thank you.
And Jacqueline Nebolini.
Yes, Your Honor, also North Broward, this is the city of Hollywood, I'm covering for that as well, medical reset.
Your Honor,
Yes.
to advise the court, I saw, I was CC'd, I believe Your Honor was also CC'd on an email from the inmate mental health specialist at the jail recommending Ms. Nebuloni for mental health order.
Okay, so I will, if you have no objection, I'll sign the order to transfer to Judge Lerner Wren. Okay?
Yes, that's
All
fine,
right.
Judge, thank you.
Okay. Yes, ma'am. Danielle Nicholas.
Miss
Is that Miss Nicholas?
Miss Nicholas
No.
indicated to
Yes.
me that she's represented by Jim Lewis.
Okay,
I called Mr. Lewis and left a message for him, but I have not heard back yet.
okay. Miss Nicholas? If we can turn her microphone on, please. All right, Miss Nicholas, when did you hire Mr. Lewis?
Several years ago. He's always been my attorney.
Okay, I understand that he's always been your attorney, but have you retained him for this case?
No.
All right? Well, so then he's not your attorney as to this case, because you have not yet retained him.
Okay.
So, we can wait all morning and to have Mr. Lewis say he does not represent you at this time, or I don't know, maybe they'll come in and take the case. But, I just want you to know, if we wait 2 hours and then Mr. Lewis says, I don't represent you on this case, because he represented you many years ago, does not mean he's representing you now unless you put him on a lifetime retainer. Do you understand that?
Yes.
All right, so we can leave it till the end of the docket and see if Mr. Lewis calls us back. But I just want you to know that, just because an attorney represented you many years ago does not mean that they're representing you today.
Thank you.
She has a pending what?
I'm using
Okay, all right. We'll recall Ms. Nicholas at the end. Yes, ma'am. Okay, all right.
Are you, Mr. Sweet? You are.
All right, Jasmine McCartney.
So ridiculous. We're resetting all this crap. See, you phone you, see your judge.
You said, John.
I'm sorry, Ms. McCartney's a reset?
Yes.
What page is he on?
McCartney's a reset.
13. Wait.
Takesha Williams,
Not 13.
She's a medical reset also.
okay.
Sweetie.
Shanae Woodside,
Judge, she's here present at Maine approaching.
okay. All right, Ms. Woodside, you are before the court this morning for one count of grand theft. And the court does find probable cause. I'll hear from the parties as to bond.
Judge, I'm going to be requesting that the court consider releasing Miss Woodside straight ROR. My understanding is she has a clean record. She's a registered voter here in South Florida. She's 29 years old, been here her whole entire life, has very strong ties to community, a graduate of Norland High School. Right now, she's currently looking for employment. She lives with her in Miami Gardens with her father, and they've been residing there for the past 12 years. She assured me she will be coming back to court. She's not a flight risk. Considering her strong ties, Judge, I'm asking for the court to consider releasing her straight ROR.
She has no history, Judge.
Okay, so I'll grant the ROR.
Thank you, Judge.
And ma'am, please make sure the clerk has your correct mailing address so that you get your mail if you have to come back to court.
Thank you, Judge.
Okay, LaShondra Graham,
Come on up, Ms. Graham. She's approaching, Judge.
Ms. Graham, you are before the court this morning for two counts of interfering with the custody of a minor, and the court does find probable cause.
Judge, we're going to be asking if we can ask confinement status to see if her bond's been posted.
Okay?
Was it posted?
It has not been posted.
No problem, Judge. She did give me the phone numbers of her family, and I intend on calling them afterwards to make sure everything is on track as far as her getting bonded out.
I'm going to be asking for, Your Honor, respectfully, I'm going to be asking for a significant bond increase. I understand that she's been charged with 2 counts for interfering with custody of a minor. Frankly, I think this was grossly undercharged. These allegations would support a finding of kidnapping, frankly. I'm greatly concerned for the welfare and safety of these 2 children, Your Honor. I'm requesting a $50,000 bond on each count, no victim contact, pretrial release of the GPS monitor.
Judge, what you haven't heard is my understanding is she basically has a clean record. She's been here her whole life. She is working and going to school. She works as a medical assistant, and she's trying to pursue her nursing license, Judge. She has very strong ties to the community. She will be coming back to court. Judge, I'm asking at this time to leave the bond in place.
I'm going to deny that. When I read this probable cause affidavit, there was a great cause for concern. 2 children were taken from school and then told that they would never see their mother again. And phone calls were made to the mother and text messages telling them she'll never see her children again. And it took hours for the children to be found and returned. So at this time, the court is going to impose on both counts a $10,000 bond and no contact with either the minor children or their parents. And I'm also going to add a level 2 GPS. Okay, Pashina Elsie.
Paul Ryan, Your Honor.
Ms. Elsie is before the court. Count 1 is grand theft, and count 2 is a misdemeanor KPS for operating without a valid license. The court
Yeah.
find probable cause.
Judge, I'd ask you to consider releasing Miss Elsie to pretrial release if her record isn't too bad. I don't know that she's going to be able to make a $1,250 bond.
Okay,
Judge. Your Honor, I'm showing, my concern is, I'm looking at her juvenile history and I see multiple arrests or detentions for the same offense. They were all at a date, but I see at least 1, 2, 3, 4, 5, 6, 7. Over 20 orders from judges for pickup orders for either absconding or failures to appear.
The fact remains, this is a nonviolent offense, and it looks like the victim in the case was going to check into a hotel room with her, and that's when she allegedly took the car. And as I say, Judge, I don't think she's going to be able to make a $1,250 bond. So, again, I would ask the court to consider pretrial release.
right, the court will grant Ms. Elsie pretrial release with a level 2 GPS. All right, Erica Joseph,
Paul Ryan again, Your Honor.
okay. All right, Ms. Joseph, you are before the court today. Count 1 is petty theft, and count 2 is use of a anti-shoplifting control device. The court does find probable cause. And I've been advised, ma'am, that your bond has been posted. Good luck. Jabari Rhymes,
Mr. Rhymes is approaching, Judge. He's here at Maine. Come on up, sir.
Judge on Jabari Rhymes, he was seen in front of Judge Al Spector. In count 3, he received pre-trial GPS, but she did not address count 1 and 2 for the lack of Was that one of the, no. All right. So she addressed what, count 3?
Yes, and she gave count 3 pre-child GPS, but she did not address count 1 and 2.
Your Honor should have the order signed by Judge Allspector in your packet.
Right, but,
Judge, being Mr. Rhymes, I know he's
but
very
why was,
confused.
why, just hold on just a moment. So why was
I
1 and
can't
2,
hear.
why was 1 and 2 not addressed?
He might not have been booked on it at that point, Your Honor. I'm just speculating. Judge Allspector might not have even been aware that that case existed.
Okay. All right. I have a probable cause determination paperwork that shows that Mr. Rhymes is before the court. Count 1 is aggravated stalking after an injunction. Count 2 is pretrial release violation for a domestic violence matter. And then count 3 is a felony battery matter, which I do have an attached order that was signed by Judge Allspector on May 9th, releasing Mr. Rhymes on that charge to pretrial release with a GPS monitor. Okay? And a stay-away order, a 1-mile distance limitation from the complainant's home and place of employment. Okay, so 1 is not, 3 is not for the court's determination today. I do find probable cause as to 1 and 2.
And Judge, that's what me and Mr. Rhymes were talking about earlier today. He said that he was in front of Judge Allspector, and he was of the understanding that this was all addressed, and he was going to be released on pretrial with the monitor. So that's what led to the confusion. My understanding is, and I'm sure Mr. Lunder will go ahead and enlighten us some more. I believe he's been out on a previous on a domestic situation, which he's been reporting, adhering to conditions. And I don't know if these cases now if these were change of charge capiases or these new law offense or not in custody capias from the same incident date. So Mr. Rhymes just doesn't know what's going on in reference to why he's here today.
I can enlighten, Your Honor. The reason he's before the court is because he has not been following conditions. Your Honor, he was arrested in March for a misdemeanor battery against this victim. He was given a bond, ordered to have no contact. As you can see in the allegations, he immediately began violating that no contact order by having contact, attempting to make contact with the victim. One moment. I won't go into the details. You can see he attempted to contact her via text and phone call at least 50 times. Your Honor, this has been investigated, and the state has filed a not in custody information. I would note the other case was upfiled from misdemeanor to a felony battery. The prior battery is against the same victim. Your Honor, I don't know that Judge Allspector was aware of these allegations of Mr. Rhymes violating the no contact order and an injunction, but I would be seeking a $20,000 bond on count 1, a $5,000 bond on count 2, no victim contact, pretrial release of the GPS monitor. I know Judge Allspector put an open schedule on the upfile. I'm going to be asking for level 2 based on these additional serious allegations.
And Judge, I'm going to be asking the court to impose the same conditions as what Judge Allspector imposed yesterday, pre-trial with the GPS monitor. My understanding, Judge, is this was addressed. In fact, I believe, according to Mr. Rhymes, I believe it was the prosecutor that actually wanted and had the victim somehow communicate with the court yesterday because they were inquiring as far as the victim's concerns and as far as the level of contact. And my understanding is that the court heard directly or indirectly from the victim herself, and then ultimately the judge, after hearing all that information, imposed pretrial with the GPS monitor. So if the court was in a better position yesterday and actually heard from the victim directly and considered this appropriate, that's why I'm asking at this time for the court to consider pretrial with the GPS monitor on counts 1 and 2 as well. Mr. Rhymes has advised me right now he's been going to court. He has a public defender. He's having his day in court, what's currently open right now, and he's working 3 jobs, Judge. He's trying to survive. He lives here locally. Judge, we're asking for him to continue to be supervised on the conditions that Judge Allspector set yesterday.
And Your Honor, I'm going to, for record purposes, I'm going to make reference to you have 2 different case numbers. Clearly, 194267 CF10A was addressed by Judge Allspector. In the Odyssey, he was scheduled for arraignment. She prepared an order and signed off on that order. Mr. Romero is alleging that 194560 CF10A, the case before the court this morning, was also addressed. There is no record of that. So I would ask, there is no record of
That's
it.
not what I'm saying. Judge, what I'm saying is Judge Alspector heard directly or indirectly
All
from the
right, now,
victim
Mr.
yesterday.
Okay, Mr. Romero, I heard what you said, okay?
Okay.
There are two cases that are on the docket. Obviously, Judge Alspector did not address that other case because there is only one case number on this order. This is two other counts that's separate from the felony battery. So this morning to say that Judge Alspector heard all of that, and I don't know if she did, but that's not reflected on this order that's before me. So today, I have another case that I have to consider and set release conditions. So I don't know why we're going back and forth on these two cases and what Judge Alspector heard, because even if she heard it, there was no ruling on it. So that's what's before me today.
I didn't mean to upset the court, Judge.
Okay, so it's something totally different. It's a different case number, totally different. And the charge is aggravated stalking, and then count two is a violation of pre-trial release conditions. And so, I find probable cause for counts 1 and 2. I am going to impose a $20,000 bond on one, and I will impose a $5,000 bond on count 2, and it is going to be with a level 2 GPS for a separate case other than what Judge Alspector heard yesterday.
Yes, Judge, separate case, same victim, yes.
Right, separate case, same victim. That's correct.
Your Honor, just for record, the court's ordering no victim contact on the second case.
Yes, no victim contact.
Thank you.
Yes, ma'am. All right, Eugene Anderson, who's on page 9, is he in the room? There's someone in the courtroom who's signed in on Mr. Anderson.
Yeah, he's next on the docket, Judge.
Okay? All right, Mr. Anderson is before the court on count 1 is an aggravated battery where the defendant knew or should have known that the victim was pregnant. Okay, good morning, folks. Good morning. So the court does find probable cause, and I'll hear from the parties as to bond.
One moment, Your Honor. Your Honor, upon reviewing the probable cause affidavit, excuse me, I'm going to be requesting a $15,000 bond. Pretrial release of the GPS monitor, no victim contact. I'm concerned about the level of violence, but what makes it more aggravating is that the alleged victim, according to the report, is 8 months pregnant. The allegations are that Mr. Anderson punched her in her stomach several times. The victim had to be brought to Memorial Regional for treatment, Your Honor.
Okay?
Judge, we're going to be requesting a $5,000 bond on Mr. Anderson's behalf with standard pretrial. He's been here his whole entire life. He's 23 years old. He lives with his father. He's grateful that his father's here for support. My understanding is he's going to be totally relying on his father to help post his monetary bond. Now, he's also working. He works at Texas Roadhouse, where he just got that job approximately 3 months ago, making about $11 an hour. He will be abiding by the court order as far as no contact. My understanding is they do not live together. So, Judge, we're asking for a $5,000 bond with pretrial release.
All right, good morning, folks. I know you're here this morning. Is there something that you wish to say to me today, sir?
I'm just here with the moral support.
Okay. All right.
The bonding him out, sir? How much can you afford?
I guess he didn't bond.
Can you come up with $500? All right, they could make a $5,000 bond, Judge.
All right, folks, I have a probable cause affidavit in front of me. This is what I have to make my determination based on. The law says within the four corners of this affidavit. And so this affidavit tells me that Mr. Anderson pushed the victim, she fell to the ground, and that he began to kick her while she was on the ground. She's 8 months pregnant. Then he punched her in her face that caused a laceration to the inside of her bottom lip, and then punched her in her stomach several times. That's what I have to work with this morning. And so the court does find probable cause this morning, and I am going to impose a bond of $15,000 with a level 2 GPS. No victim contact until further order of the court. That means no phone calls, no text messages, no social media, no family member trying to get in touch with the alleged victim on his behalf. Do you understand that? All right, thank you. Okay, did the attorney who signed in, she left? Okay,
I believe she'll be back.
okay. Leodam Gonzalez,
He's here, President May.
Tafika Carr on his behalf, covering for Mr. Steve Shate.
okay. So Mr. Gonzalez has 10 misdemeanor KPS matters before the court,
Correct.
both municipal ordinance violations and state violations.
Mr. Shade is requesting that his municipal city ordinance cases just go straight to the division.
All right, the court does find probable cause, and at this time, based on the number of charges, the court will send everything to its division.
Thank you, Your Honor.
You're welcome. Timothy Erler,
Yes, Your Honor, he was at Maine. I spoke to the deputy. I'm asking to be appointed, but they indicated that they took him back to his cell because he was being disruptive, not for any medical reasons, but I will be able to take care of him tomorrow.
okay, then I'll reset Mr. Erler to tomorrow.
Thank you, Your Honor.
Morris Collins,
Mr. Early, no. Mr. Early? Judge, this is Early.
he's there? Okay.
Yeah.
All right, Mr. Erler, we apologize. We thought that you were taken back to your cell. So Mr. Erler is before the court on a municipal ordinance violation on a KPS for solicitation and display. And the court does find probable cause.
Your Honor, be inclined to extend an offer to allow him to resolve today.
All right, Mr. Erler, can you hear me, sir?
Can you hear the,
Mr. Erler, can you hear me?
Yes,
Okay. Sir, do you wish to resolve your case today?
yes, I do.
And the court, I will sentence you to adjudication and time served if you wish to resolve your case. Are you willing to accept that offer, sir?
Yes, I am.
Okay, sir, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes,
Okay, sir, you can put your hand down. Mr. Erler, is anyone forcing you to resolve your case today?
no,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with the attorney?
No, I'd just like to resolve this
Okay,
today.
all right, I understand, but I have to ask you all these questions on the record so that it is clear that this is what you want to do, okay?
Yeah, okay.
All right. So, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And sir, do you understand that, have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you're not a US citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
No, I was born in Pittsburgh, 1973.
That's
Or
a,
no, I've been here since 1973.
That's okay, sir. Again, it's another question that I have to ask you as part of taking the plea, okay?
Okay.
All right, so then what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Your Honor, how much
Thank
time are you
you.
giving to pay court costs?
6 months.
6 months, thank
Yeah,
you.
6 months. Okay, Norris Collins.
Mr. Collins, come on up, please. Please approach the judge.
Mr. Collins, you are before the court on 2 misdemeanor KPS for 2 petty theft charges, and the court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Collins' ROR on standard pretrial. My understanding of speaking with Mr. Collins, he told me it was totally his mistake that he missed going to court. He won't let that happen again, Judge. He lives here locally in Hollywood. He's looking for employment. So, Judge, we're asking to consider ROR and pretrial release.
Your Honor, state with opposing. He missed 2 separate court dates on 2 separate thefts. He was arrested last December on a new petty theft, and at that time he had an active capias on a criminal mischief for failing to appear in court.
Okay. These KPSs, one is February 14th of 2019, and the second one is April 17th of 2019. He failed to appear for arraignment. So at this time, the court does find probable cause, and I'm leaving the standard bonds in place. Ronald Hessen.
Mr. Hessen, come on up, please.
Mr. Hessen is before the court on a KPS matter for carrying an open container in public. It's a municipal ordinance violation. Mr. Hessen, what do you wish to do today, sir? I'm so,
Just cleared up,
okay.
whatever.
All right, Mr. Hessen, if you wish to resolve your case today, you'll be sentenced to adjudication and time served. Do you wish to do that, sir?
Yes, ma'am.
All right. Mr. Hessen, can you raise your right hand as best you can? Do you swear or affirm to tell the truth?
Yes, sir.
You can put your hand down, sir. Mr. Hessen, is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
Yes, I was under the alcohol.
All right. So then I'll reset your case for another time. Okay? I will send it to the division. I believe he said he's,
Did you just reset? Are you saying that you're under the influence of alcohol right now?
Oh, no.
oh,
Do you want me to speak to him?
well, let's,
I just had the one open container.
let's reset it.
Could you reset it till
Yeah.
tomorrow?
Yes, I'll reset it till tomorrow.
I'll see you in the morning. We'll take care of it tomorrow. Let's give you. Okay.
Okay.
Tomorrow.
Huh?
All right, David Earl.
Judge, reset.
Okay, thank you. Mr. Earl has been reset. John Bailey,
Mr. Bailey's here present, Judge. Come on up, Mr. Bailey. Remember page 22. No, remember page 22. Come on up, sir. He's approaching, Judge.
all right, Mr. Bailey is before the court for a criminal mischief charge, and the court does find probable cause.
Judge, in speaking with Mr. Bailey, he unfortunately is financially indigent. He's homeless. He's 63 years old, been here since 1974. He's asking if the court would consider releasing him ROR on this charge.
Your Honor, the issue is, Mr. Bailey's been here multiple times over the past couple years, multiple times for destroying other people's property. He pled out a trespass a week ago. He was before the court, I believe, on this May 1st or May 2nd. Battery, resisting without violence last year, trespass last year, another criminal mischief last year, another criminal mischief last year, another trespass last year. I know on 2 occasions, one it was at, I believe, a bar where he destroyed their property with a cane. There was an incident outside a grocery store where he allegedly attacked someone. There was a criminal mischief where he destroyed property at a gas station.
All right, I do remember Mr. Bailey, and then there's a $200 in property damage with this arrest. So I believe at this time, I'm gonna send Mr. Bailey to his division judge, and then maybe something can be worked out. Can he go to Judge Lerner Wren?
That's where I would prefer to go.
All right, so then we will sign an order to transfer him to Judge Lerner Wren's division then, okay? All right,
I'll let her, Jay, know.
thank you.
There's something going on.
Yes, Michael Knight,
Mr. Knight, come on up, please. He's approaching, Judge.
Mr. Knight is before the court for resisting officer without violence. The court does find probable cause.
Judge, in speaking with Mr. Knight, he wishes to resolve this matter today.
Your Honor, he's currently on pretrial for case number 19005126 CF10A for possession of cocaine, resist officer, obstruct without violence. He actually never reported to pretrial after his release. We're asking that you revoke his pretrial in this case.
When was he placed on pretrial?
April 21st. And his officer has been trying to get in contact with him.
Okay. All right, so as to the new arrest, I will not entertain a plea offer today. Mr. Knight's bond is $100. On case number 19-005-126, CF10A, Mr. Knight was placed on pretrial supervision for possession of cocaine and resisting officer without violence. Based on the information provided from pretrial today, he never even bothered to show up. And so at this time, the court will grant pretrial's request to revoke pretrial. And on count 1, the court's going to impose a $1,000 bond. And then on 2, $500. Thomas Gary.
He's approaching, Judge.
Mr. Gary is before the court this morning for disorderly intoxication in a public place, and the court does find probable cause.
Judge, he wishes to resolve this matter today.
Okay, does the state have an offer for Mr. Gary?
Yes, Your Honor, just one moment. Your Honor, the offer is going to be a withholding court cost. The only other thing I'd want to bring to the court's attention, because I imagine with court notice, court cost type of things, the clerks might still send mail. It shows an address of Colorado Springs, but it shows Florida, so unless that's corrected, to Colorado, he will never get that, any court cost notices.
Okay. All right, so, Mr. Gary, you need to make sure, well, it's not, it probably is not him. It says Colorado Springs, Florida,
Yeah, no, I know.
and it does have the right zip code. That's not a Florida zip code.
No, I know, that's why I double checked. and,
Okay.
Yeah, and I don't know if we want to, if we can even address the clerk now, just to make, if they can notice it, that it should be Colorado and not
Madam
Florida.
Clerk, can you make sure that that correction is made? It's just that it doesn't have the correct state. All right, it says Colorado Springs, Florida, so it needs to say Colorado. Right, all right, thank you. All right, Mr. Gary, you wish to resolve your case today, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Gary, do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
And you understand, sir, that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, sir, then what plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is withhold adjudication and court costs. Good luck. Canson, St. Fort.
Mr. St. Ford is in North Broward, Judge. He would like to resolve this matter this morning.
Okay, Mr. St. Ford, you are before the court this morning for petty theft, and the court does find probable cause.
Yes.
State, do you have an offer for Mr. St. Ford?
I do, Judge. It would be an adjudication, time served, no return to this Walmart at 5555 West Atlantic Boulevard in Margate.
Is that
Mr.
what you'd like to do, Mr. Ford?
Yes, yes, absolutely.
Okay.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am. Yes, Your Honor.
You can put your hand down. Mr. St. Ford, is anyone forcing you to resolve your case today?
No, Your Honor.
And do you need any more time to speak with your attorney?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, not at all.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Absolutely.
And sir, have you ever been treated for mental or emotional illness?
I have.
And is there anything about that illness today that would affect you making an intelligent decision about this case?
Not at all, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I do understand.
Then what plea do you wish to enter, sir?
No contest, ma'am.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served, and it also comes with an order not to return to that Walmart. Do you understand that, sir?
I do understand, Your Honor.
Okay, all right, good luck.
I do appreciate that. Thank you.
You're welcome.
Good luck, Canson.
I appreciate you, sir.
Raymond Serrano.
Judge, he's here present, and he declined to service as a public defender.
All right, Mr. Serrano, you are before the court for 3 traffic KPS matters. Driving while license suspended, operating without a valid license, and the third one is also driving while license suspended. Those 3 count, when the KPS was issued, there were $500 bond attached to each of them, so you have a total of $1,500 in bond at this time. So what do you wish to do today, sir?
I'm bonding out.
Okay. All right, so the court finds probable cause and your total bond is $1,500. Good luck, sir.
Thank you.
Christopher Gibbons.
Bonded, Judge?
Thank you. Johan Velasquez Wick.
He's approaching, Judge. Come on up, sir.
Sir, you are before the court today. Count 1 is petty theft, and count 2 is possession of cannabis 20 grams or less. The court does find probable cause.
Judge, on this misdemeanor cannabis $100 bond, we're going to be asking if the state has any objection with having Mr. Velasquez release ROR on it.
Okay.
Fine, Your Honor.
All right, so Mr. Velasquez will be released ROR on this count.
Thanks, Judge.
Quasi Simpson.
Come on up, sir. He's approaching, Judge.
All right, Mr. Simpson, you are before the court on a municipal ordinance violation. The charge is trespassing. All right, and so the court does find probable cause. What does Mr. Simpson wish to do today?
And it looks like he failed to appear for his arraignment. Does Your Honor have an offer that you can extend to him?
All right, Mr. Simpson, can you hear us?
Nah,
He can't.
Well, you just responded, so you must have heard me.
I didn't hear what she said.
Okay. Well, she's the attorney that's representing you, and she said that it appears that you failed to miss court, that you missed court. You failed to appear for court, and so I am asking you now, based on that, do you wish to resolve your case today?
Yes.
Okay. And so, sir, if you wish to resolve your case today, I will sentence you to adjudication and time served. Do you wish to accept that?
Yes.
Okay, then, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Simpson, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And sir, do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
Okay, sir, then what plea do you wish to enter? Guilty or no contest?
Not guilty.
No, it's got to be guilty or no contest.
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck.
Thank you, Your Honor.
Okay? All right, Leon Davis.
Also at Maine, Your Honor. Should be approaching.
Mr. Davis is here present, Judge.
All right, thank you. Mr. Davis is before the court. It's a municipal ordinance violation on a possession of controlled substance. The court does find probable cause. What does Mr. Davis wish to do?
Your Honor, he would like to resolve, but I would ask if Your Honor be inclined to giving him a leave hold. He said he has a valid driver's license.
Okay. All right. Do we? Thank you.
Thank you. Please stay.
Yes, Your Honor, according to DHSMV, his license is valid.
Thank you very much.
You're welcome.
All right, Mr. Davis, if you wish to resolve your case, I'll sentence you to withhold adjudication and court costs. Do you want to do that, sir?
Do you want to resolve your case to a withhold and court costs?
Yes.
All right, sir, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Davis, do you understand everything that's going on here today?
Yes.
And is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
Not at all.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, sir, then what plea do you wish to enter?
No contest.
Sir, I accept your no contest plea. I find that it's freely and voluntarily given. And Mr. Davis, your sentence is withhold adjudication and court costs. Good luck, sir.
Thank you so much, Your Honor.
If I may, I suspect you don't have the paperwork. Latoris Ford is physically on the docket again. We discussed him yesterday. It's a DOP at a Judge Poe's division. You'd ask the clerk to remove him from the docket. I'm just asking to make this request again, only because since none of us are gonna be here tomorrow, I just don't wanna see any confusion over the weekend.
So, I'm sorry, if you, is it, do I have paper, what's the
No,
last
you won't
name?
have paperwork.
I don't have
Here,
paperwork,
if I may.
because I don't go by the docket, because that's
Yeah,
too
no, I
many
know.
things
That's
to
why,
maneuver.
For some reason, you'll see he's been reset every day this week.
So Latorius Fort, we sent him to division.
He wasn't here yesterday. He's been reset every day because he's gone, because he went to division.
Oh, he already went to division.
Yes, and,
All right, so Madam Clerks, if you could delete, don't reset Mr. Fort. Don't put him as a reset, okay? He's already, oh, this is yours, sorry. What page was that? Just so, page 60. Okay, all right, thank you. Okay. Michael Taylor,
All right.
good morning, Mr. Taylor.
Good morning, Your Honor.
You are before the court today for additional charges. So this is charge number 7 is grand theft. Number 8 is felony violation of probation, which is a no bond hold. And 8 is also a grand theft, okay? The court does find probable cause, and,
Judge, I'd ask you to leave the bonds in place in light of the two, actually, Mr. Taylor has 2 no bond holds, so.
okay, so at this time, I will leave the standard bonds that are in place, sir, okay?
Okay.
All right. Then Darian Anderson,
North
North
Broward.
Broward, Your Honor. Good morning.
good morning, Mr. Anderson. You are before the court today. These are also additional charges. Now, charge number 3, aggravated assault with a deadly weapon without intent to kill. Count 4 is a felony violation of probation with a no bond hold. The court does find probable cause. Does anyone wish to be heard as to bond?
Your Honor, I'm gonna be requesting a $10,000 bond, no victim contact, no possession of any firearms. This is based on the allegations that Mr. Anderson threatened the victim at gunpoint during what appears to be a road rage situation. He's currently being held, no bond on a VOP. He also, 2011, was convicted of burglary of a dwelling with battery, felony battery, great bodily harm, and criminal mischief, sentenced to 5 years state prison as a habitual offender.
In light of the fact that Mr. Anderson has a no bond hold, Judge, he's gonna have to go in front of his division judge to resolve these matters in any event.
Okay. All right, so Mr. Anderson, at this time, as to charge number 3, the court will impose $10,000 bond and no victim contact until further order of the court. Do you understand that, sir?
Yes, ma'am.
All right, sir, good luck. Michael Mancini,
He's here at main, Judge.
Good morning, Your Honor.
Good morning, sir. You are before the court. These are for additional charges. Charge number 4 is grand theft, and number 5 is resisting officer without violence. And the court does find probable cause.
Judge, I understand Mr. Mancini is currently being held no bond in another matter, so at this time, nothing to add in respect to the bonds.
All right? Then the standard bonds are in place. Good luck, sir. Damon Nicholas.
Mr. Nicholas is approaching. Come on up, Mr. Nicholas.
All right, Mr. Nicholas, you are before the court. These are additional charges. Charge number 9, grand theft, and number 10 is false owner info for pawn items. And so the court does find probable cause. And the court is aware that Mr. Nicholas is in custody on some other counts.
Your Honor revoked his bond.
I did, and so I'll leave these standard bonds in place, okay? Jared Karibo.
Hi, ma'am. How are you? No problem.
Mr. Karibo, I'm well. You are before the court today for 1 count of possession of cocaine, and count 2 is possession of drug paraphernalia.
Yes, ma'am. Yes, ma'am.
The court does find probable cause.
Judge, I know Mr. Karibo has had some pretty substantial contact with the criminal justice system in the past, but he's not going to be able to make a $1,000 bond at this point in time. When he was arrested, he did have some money on him, but from what he tells me, the officers took his money and put it back in his house. And unfortunately, the person he lives with is not the most trustworthy, so he doesn't even know if that money's still available.
Okay,
I'm going to ask the court for pretrial release. He's been here for 20 years. He's been living in the same location for the last 6 months. He makes about $1,600
Carrabba's.
working at Carrabba's. His rent is $900.
My rent is $900 a month, ma'am.
all right, if you'll let your attorney speak, he's saying all those things
I'm
that you're
sorry.
repeating,
I'm
okay?
so sorry.
Just let
I'm
him
so
speak,
sorry.
okay?
Yes,
That's all we have to say.
All right, thank you.
Your Honor,
I'm sorry.
I'm going to be requesting that the bond be kept in place. He's got 21 prior felony convictions in the state of Florida. He was most recently released from state prison in February of 2018. That was after being sentenced to a year and a day state prison in Palm Beach for felony theft, grand theft, possession of heroin, and cell delivery of heroin. I'm also showing that he has an open felony out of Martin County, 2018, burglary of a dwelling and felony theft.
As I said, Judge, he has had some contact with the criminal justice system. This is a nonviolent, third-degree felony, a drug possession case. He's not going to be able to bond out on a $1,000 bond, so I would ask the court for pretrial release and whatever other conditions the court deems appropriate.
All right, at this time, the court will grant pretrial release with random drug testing, okay?
Thank you.
So let me give you the instructions. That sheet that the deputy just handed you, it is to the pretrial, directions to the pretrial office. You must report, today's Friday if you get out in time, but if not, by Monday morning, you need to report. If you don't report, there will be a warrant issued for your arrest. And also, as part of the pretrial supervision, sir, you will be subjected to random drug testing. Do you understand that?
Yes, ma'am.
All right, good luck, sir.
Thank you so much, ma'am. Amen.
Okay, Curtis Hunter.
He's here, President Judge, I mean.
Okay, Mr. Hunter is before the court. Count one is aggravated battery causing bodily harm. Count two is aggravated assault with a deadly weapon without intent to kill. And count three is trespassing on property not structure or conveyance. All right, the court does find probable cause. I know there, I don't know if there are mental health problems, but it's also a felony matter, so. All right, so I'll hear from the parties in regards to bond.
Your Honor, the state is seeking a $10,000 bond on count one, a $7,500 bond on count two. Your Honor, I would note Mr. Hunter is currently out on ROR for a delivery of cocaine. The state would be recommending that his bond be revoked in that matter. Since that case, he has picked up and pled out 4 trespasses. He was just arrested on another trespass last week of April, and he posted a $100 bond and was released on that. He has priors for delivery of cocaine, strong arm robbery, grand theft, battery, tampering with evidence. And would also, Your Honor, I'd also be requesting no victim contact in this matter.
Okay,
Speaking to Mr. Hunter, unfortunately, he's financially indigent at this time. He's homeless. He's been here his whole entire life. He's been living in our community, Judge. Right now, the good news is he just found a job. He was actually supposed to start, I believe today, in a hotel in Fort Lauderdale in their maintenance department. Right now, Judge, from what he advised me, no one's going to be able to post monetary bond. So, Judge, I'd ask you to take that into consideration, determining reasonable release conditions for Mr. Hunter. I'm also going to ask you to sign 2 orders, one a photo order so we can photograph his injuries, and a medical screening order, Judge, as well.
all right, I will sign those orders, but it appears that Mr. Hunter did get the benefit. He was released on his own recognizance, and now we're before the court again on new charges.
Judge,
So-
if you're going to address the bond on the case that Mr. Hunter is out on at the request of the state, that you revoke that bond, we're going to ask for 3 hours' notice to prepare for that hearing.
Okay, I am not going to address that at this time. I will just address what's, the case that's before me. I am going to impose a bond on count one, $10,000, count two, $7,500, and no victim contact. Ms. Shemtov, well, let me see if your client is in the room. Clayson Swaby on page 19, is he in the room? He has private counsel.
He's approaching, Judge.
Okay, thank you.
Come on up, sir. There's your private attorney.
To be in your courtroom.
Good morning.
Judge, I represent Mr. Clayton Swaby. He is being charged on a felony battery. We ask that a bond be set at $5,000. His history is not bad. He has never absconded before. There's really no reason for it to be more than $5,000. He has ties to the community. And I think a $5,000 bond is fair and just.
Your Honor, the state is going to be requesting a $10,000 bond, no victim contact. This is based on not only the allegations where allegedly Mr. Swaby attacked and broke the victim's jaw. 2 other men held him, so he cannot even defend himself. I would note his history is dated. He has been to state prison 2003, grand theft auto and battery on a law enforcement officer, a year in a day state prison. So I would note there was allegations and convictions for violence in his past. 1999 out of Palm Beach County, burglary of a structure and grand theft between $20,000 and $100,000. He was sentenced to a year and 6 months state prison. One moment, Judge. I'll leave it at that, Your Honor.
Right?
Judge, yeah, those are very old. He's been out of trouble since, and he's never absconded. There's no allegation that he's ever missed court at all.
Okay. Well, the allegations before the court are that two persons held the alleged victim while I think you pronounce his last name as Swabi, broke the alleged victim's jaw. And based on those allegations, the court finds that a reasonable bond at this time is $10,000, no victim contact until further order of the court.
What about if we do something with an ankle monitor and the 10,000 and 5,000? That way, it's a little bit more reasonable. Or maybe pretrial.
Well, if I put him on pre-trial, it's going to be level 1, and then, I'm gonna hear that he can't leave his house, so.
Okay.
That's
So then
his.
we'll keep it at the 10,000.
Okay,
All right.
all right,
I appreciate it. Thank you.
no problem. Wilson Camillus.
He's approaching, Judge.
All right, Mr. Camillus is before the court on count 1, possession of MDMA, and the court does find probable cause.
Judge, we're going to be requesting that the court consider releasing Mr. Camillus RWAR or on the alternative on pretrial release. He's been living in our community for 24 years, Judge. He's 30 years old. At this time, he does work. He works for a mobile detailing company. Unfortunately, he did tell me because of the amount of rain, business has been real slow. So right now, he's going through kind of a financial crisis. He lives locally in Pompano Beach, but we're asking on this nonviolent offense to consider releasing him RWAR or on the alternative on pretrial release.
Your Honor, one moment. Your Honor, Mr. Camillus is on ROR in drug court. Actually, it's before Judge Weeks now for pending possession of heroin from 2017. I've seen that there's been capiases issued multiple times in that matter. I would ask that the bond be kept at 1,000. The state's recommendation be that his ROR be revoked or his release conditions are revoked in the 2017 matter.
All right, the standard bond on count 1 is $1,000. And as to the request to revoke the bond, I know the case that the state is relying on, I did have an opportunity to review it before yesterday, and then I looked at it again today. It's Chavis Johnson versus State of Florida and Rick L. Bradshaw. It is a case out of the 4th DCA. The one thing, though, I know that it addressed that the first appearance court, a judge, can revoke or, well, in this case, the first appearance judge did not revoke, and the issue is something different, but it does show that the first appearance court could make those revocations. What is not clear is whether or not there was that 3-hour requirement, and then the 3-hour requirement does say that it could be for a modification of bail or by showing good cause, which I believe is what was argued yesterday. But the court just needs more time to be able to make that distinction.
And,
as
Your
to
Honor,
the time.
the state will research the matter also.
Okay.
If I see anything, obviously, I'll provide
Right.
case law to defense and the court.
Okay, thank you.
We're not disputing that the court has the authority to do that.
It's the 3-hour requirement that I'm talking
But
about.
I think once the state requests it, that to me is the difference. Once the state says we're asking the court to revoke his bond, our position is at that point in time, it's a state motion. It's not the court doing it of its own volition.
Right,
So our position is if the state wants to, anytime the state moves to revoke someone's bond, we should be entitled an opportunity to prepare for that hearing.
I got you. It's just not clear, though, in the case law, whether or not, that issue was, that was not an issue. So
know.
we don't know, it did say that the state requested it.
Yes.
And that the court, so I don't know if there was that discussion about the 3-hour, or if that changes the rules or anything, so.
We're having that discussion now.
Right. Okay, all right, so let's go to Andrew Spence.
Mr. Spence, come on up, please. Please approach, sir.
All right, Mr. Spence is before the court on an aggravated assault with a deadly weapon without intent to kill. Count 2 is carrying a concealed firearm, and count 3 is possession of cannabis, 20 grams or less, and the court does find probable cause. And I hear from the parties as to bond.
Your Honor, based on the allegations, the state would be seeking a $10,000 bond, no victim contact, no possession of any firearms or weapons.
Did you say 10,000?
10,000 on one, I'm sorry, I'm used to count 2 having a standard bond, $1,000 on 2.
Okay.
Standard bond.
Judge, in reference to count, I believe that's reasonable, $1,000 bond. In reference to count 1, I'm gonna be asking for the court to consider $4,000 bond, which would be a total of $5,000 on Mr. Spence's behalf. He's 29, been here for about 10 years now. He works at Comcast. He's been there just for about 1 year. He basically supports, he lives with his girlfriend in North Lauderdale, where he's raising his 4-year-old daughter, Judge. Right now, he believes that his girlfriend, using the services of bondsman, if the court were inclined to set about a $5,000 bond, he's hoping that he can go ahead and fight this case from the outside, Judge. And also, we're going to be asking for a phone order as well.
All right, I'll sign the phone order. Mr. Linder, did you, if you said it, I didn't hear it. Are there any priors,
No,
Mr.
Judge, I
Spence?
did not see it.
Okay, all right. So at this time, the court will impose $5,000 on count 1, $1,000 on count 2, and
Ask for an ROR on count 3, Judge. I think the state's going to have problems establishing that Mr. Spence knew the marijuana was in the rear seat pocket of the car.
I'm gonna leave the standard bond in place on count 3. All right?
No, just ask for an order of no
And
contact.
no victim contact,
Thank you.
and no return to that location.
Judge, just clarification as far as the location, what's the address? I believe he was, it happened in front of his residence.
Oh.
That's why I wanted to.
Oh,
make-
okay. Oh, I read this earlier, so I forgot how the story transpired. So that's not an issue, okay?
Thank you, Judge.
So just only no victim contact. Thanks. Roberto Betia.
He's approaching, Judge. Come on up, sir. He's approaching.
All right, Mr. Betia is before the court for 1 count of grand theft, and the court does find probable cause. And sir, I've been advised that your bond has been posted, so good luck. Michael Powell.
Mr. Powell, come on up, sir.
Mr. Powell is before the court on one count of distribution, delivery of cocaine. The court does find probable cause.
Your Honor, he's currently on pretrial for 3 other cases. Case number 1800366 CF10A, possession of cocaine intent to deliver cell. Case number 1700554 CF10A, possession of PVP. And case number 1800263 CF10A, possession of cocaine and unlawful use of false name or identity. We're asking that you revoke his pretrial in reference to this case.
Just for clarification, when was the
All of
alleged date of
these?
incident on this new charge?
October 25, 2018.
House of Hope.
Judge, since I'd ask, considering the date of offense on this case is October of 2018, he's been on pretrial. My understanding, he's been on GPS with an open schedule. What he's been advising me, and pretrial is going to correct us if I'm wrong, he said he's been doing well, has a good rapport with his probation, with his pretrial release officer. I'm going to be asking if the court consider releasing him on the same conditions that he's on, which is, I believe, with a GPS and an open schedule.
Well, you did hear that their pretrial is asking for his pretrial supervision to be revoked on 3 cases.
Right, he's been on pretrial, I believe, it may be in mental health court, and I believe that he was, and I could be wrong, I believe he's been on it now for a number of months, and this happened October of 2018. Even though it probably happened after that date, I'm still asking the court to take in consideration that he's been on pretrial, he's not picking up new charges since October. That's why I'm making that request, Judge.
Wanted to ensure that we did the revocation. She actually sent me an email.
Despite the good rapport. Your Honor, this is now the 3rd time he's been arrested on a felony, violating his release conditions on the initial possession of PVP from 2017. So I really don't know how it can be honestly claimed that he is following his release conditions. Even if this happened all of 6-7 months ago in October, or 8 months ago.
All right, let's begin with the new arrest. The court does find probable cause, and the bond there is $2,500. Okay? All right, no, please have him come back. I'm not done.
Sir.
All right, Mr. Powell is on pretrial supervision on case numbers 18-2643 CF10A, case number 17-005547 CF10A, case number 18-003664 CF10A. Pretrial supervision is asking for the pretrial to be revoked, and the court is going to grant that pretrial revocation on all 3 cases. As to 18-2643 CF10A, the court is going to impose a bond, count 1, $1,000, and count 2, $500. On case number 17-005547 CF10A, the charge is possession of PVP. The court does find probable cause and imposes a bond. I'm sorry, I am granting pretrial's request to revoke pretrial, and at this time I'll impose a bond of $1,000. On case number 18-003664 CF10A, Mr. Powell is on pretrial for possession of cocaine with intent to sell or deliver. Pretrial is requested that the pretrial supervision be revoked. The court is going to grant that request, and impose a $2,500 bond on that case. Okay. All right, Kevin Semanas.
Medical research, Your Honor.
Okay, thank you. John Vickers.
Come on up, sir.
Mr. Vickers is before the court on counts 1, 2, and 3 are burglary, unoccupied conveyance unarmed. Count 4 is grand theft. Count 5 is petty theft. Count 6 is burglary of a dwelling or structure. Count 7 is grand theft. And count 8 is possession of cocaine. Okay, the court does find probable cause. There
Are
are,
we looking at an armed burglary on count 6?
Yes.
oh, I didn't,
So I read this
Okay, wait.
earlier.
I didn't see the armed.
It alleges, Your Honor, starting with,
Which affidavit, which,
it's mentioned in both, there's two affidavits, it's mentioned in
Right.
both. One moment.
Okay, I found it.
where did you find it?
It's on the third page, a paragraph that starts, "It should be noted that on the same evening, they say Mr. Vickers was seen or on video opening a driver's door, and that a handgun was reportedly
I
taken from underneath the
okay.
front seat."
I
So
see it.
I guess that's enough for probable cause.
All right, so as to 6, it's armed burglary, okay?
And Your Honor, I would be seeking a finding of proof evident or presumption great, and order that Mr. Vickers be held no bond. Your Honor, the allegations would satisfy the elements. He broke into a vehicle, stole a firearm, thereby arming himself during the commission of a burglary. This was, I believe it was captured on video surveillance, Your Honor. He was identified by a neighbor who's familiar with him, that has known him for years, who actually stated as far as one of the burglaries, she saw him that day wearing the same clothes that he was wearing in the video of that burglary, Your Honor. I am asking for a no bond because, as you can see, it does appear based on this, Mr. Vickers is terrorizing this neighborhood. Multiple neighbors in this neighborhood have said that crimes go unreported that Mr. Vickers commits in this neighborhood because they're out of fear of repercussions of violence from him if they speak to the law enforcement, Your Honor. I'll leave it at that, Your Honor, at this point.
I don't know that all the ancillary things the state mentioned go to whether or not proof evident and presumption great, that standard has been met. Proof evident presumption great is the highest standard that we have in the criminal justice system. It's even higher than proof beyond and to the exclusion of every reasonable doubt. It's the state's burden to establish that, and they have introduced no evidence. The report refers to videos of Mr. Vickers committing this offense, yet the state has not provided the court with any of those videos so that this court could review them for itself and make an independent decision instead of relying on a probable cause affidavit written by a police officer who didn't witness any of these crimes take place. It does not appear that any handgun was ever recovered. The victim says that a handgun was reported taken, but it's not clear, certainly not clear to the point of a proof evident presumption great that Mr. Vickers is the one who took that gun. The only way that we could really know that is if we had the video here in front of us to watch, and we don't. So based on that, Judge, I would ask the court not to make a finding of proof evident presumption great, and I would ask the court to set a bond for Mr. Vickers. If, over our objection, the court does find that the state has met that burden of proof, we would ask the court to exercise its discretion and set bond for Mr. Vickers.
And Your Honor, just to clarify, the reason I'm bringing up the ancillary information is because Mr. Reedy is requesting that even if you find proof evident or presumption great, that you use your discretion to set a bond. So, the court obviously is able to distinguish between what information is relevant to proof evident or presumption great and which information is relevant to deciding whether a bond is appropriate or not. Your Honor, if I don't provide the court with certain information before, you make a determination, well, then it's too late if you exercise your discretion. I'm making this argument because I believe that discretion shouldn't be exercised in setting a bond if you find proof evident or presumption great, because I do believe he poses a danger to not only the property, but the people of this neighborhood.
The only issue here is whether or not the state has established that proof is evident and presumption is great as to the issue as to whether Mr. Vickers is the one who took the gun from underneath the car, underneath the driver's seat of the car.
Okay, the court has reviewed the probable cause affidavits. There are two, one dated February 12th, 2019, and a second one dated February 10th of 2019. The court does make note that the report does reflect that there is surveillance system on the alleged victim's home where the observations were made, and that there was even reports from residents from the community in regards to Mr. Vickers being the person on the video wearing the same clothes, even at the time when they. And so based on that, the court does find probable cause and does find that there is sufficient evidence in the affidavits to make a preliminary finding of proof evident presumption great. This is without prejudice for the defendant to have a bond hearing based on State v. Arthur, and Mr. Vickers will be held no bond as to count 6. Okay.
And Your Honor, addressing counts 1 through 3, obviously the court just said ordered him to be held no bond on the armed burglary. I would want to bring to the court's attention that on three separate cases in 2007, Mr. Vickers was convicted of 2 counts of attempted burglary of a dwelling, 1 count of burglary of a conveyance. He was sentenced to 10-year state prison 10-year state prison as a habitual offender and a PRR offender. He was released from state prison November 16th, 2017. The state would be seeking $15,000 bonds on counts 1 through 3.
Judge, considering he has a no bond hold on count 6 and these are third-degree felonies, I'm asking the court to set a $1,000 bond on each third-degree felony. Judge, he's right now not working. He's applying for disability.
As to counts 1, 2, 3, the court will impose $5,000 bond on each of those counts. Okay, Eric Sanchez Perez.
It's pending, so let the assigned prosecutor deal with it.
Judge, he's here, but he's going to require a Spanish interpreter.
All right, thank you. All right, for the students, since we have to wait for the Spanish interpreter, I just want to say hi, just quick minute. Meredith knows. While we're waiting for the Spanish interpreter, we can, if we're ready, we can address some other persons. So Max Saint Sauveur,
He's approaching, Judge. He's here at Maine.
good morning, sir. You are before the court today for a grand theft charge, and the court does find probable cause.
Judge, my understanding is Mr. St. Sauveur, this is he has a clean record. He's a registered voter in our community. He's been here his whole entire life. He lives locally here with his sister. Considering he has a clean record, this is a nonviolent charge, I'm asking the court to consider releasing him RWAR or in the alternative to leave the standard bond in place.
I show no history, Judge.
All right, so I'll release, I'll do the ROR release on Mr. Saint Sauveur,
No,
okay?
just ask for that no return to this auto zone.
Okay,
Sunrise.
and so, to this location, sir, you cannot return there, okay? All right,
Thank you, Judge.
you're welcome. Mario Costura, is that a loan? And then Jaron Pratt,
North Route.
okay? All right, Mr. Pratt, you are before the court. Count 1 is possession with intent to sell, deliver, or manufacture cocaine within 1,000 feet of a place of worship or business. Count 2 is possession of oxycodone. Count 3 is possession of cannabis, 20 grams or less. Count 4 is possession of MDMA. Count 5 is tampering with or fabricating physical evidence. All right, the court does find probable cause, Mr. Pratt, and I've been advised that your bond has been posted. Good luck, sir.
All right, take care, Jaron. Don't miss court.
Thank you very much.
All right.
Thank you.
Harmon Brown. All right, Mr. Brown is where? Maine?
Brown? Mr.
Yes.
Oh, he bonded, Judge, sorry.
Harmon Brown bonded,
Yes.
okay. And then Walter Nelson.
Nelson, come on up, please. He's approaching, Judge, and he declined the services of public defender.
Hello, Your Honor.
Good morning, Mr. Nelson. You are before
Good morning.
you're before the court. Count 1 is possession of fentanyl. Count 2 is possession of cocaine. Count 3 is possession of drug paraphernalia. Count 4 is driving while license suspended. And the court does find probable cause as to all those counts. Mr. Nelson, is there anything you wish to say in regards to your bond?
If I could have it reduced, that'd be great.
Okay, I'll hear from the state.
Your Honor, I would have no objection to pretrial with random testing. I know in 2015, Mr. Nelson was arrested and entered into drug court for possession of oxycodone. He did successfully complete it, but it looks like that went until August 20th of last year.
All right. Okay, Mr. Nelson, I will release you to pretrial supervision, sir. And that's going to include a random drug testing. Do you understand that? And the deputy is handing you the directions at this time. You need to report to pretrial supervision. If what time do you close? At 4? The office closes at 4:30. So if you're not able to make it today, because today is Friday, you need to make sure that you report on Monday. Okay?
Yes, Your Honor.
All
Thank
right.
you. Have a good day.
All right, we have the Spanish interpreter. So we can address Eric Sanchez Perez.
He's approaching, Judge.
Mr. Perez,
Señor Pérez,
you are before the court today
usted está ante este tribunal hoy
for 70 counts
porque tiene en su contra 70 cargos
of possession of counterfeit credit cards.
de posesión de tarjetas de crédito falsificadas.
Count 71
El cargo número 71
is unlawful conveyance of fuel.
es transportar ilegalmente combustible.
And then count 72
Y el 72
is disobeying a stop sign,
es no acatar una señal de tránsito, un alto.
and that is not for magistrate.
Y eso no es un cargo para este tribunal.
Okay, the court does find probable cause,
Consideramos que existen indicios probables de delito
and I will hear from the attorneys
y ahora voy a escuchar a los abogados
in regards to your bond.
con respecto a el monto de su fianza.
Your Honor, I'm going to be requesting that the bonds be kept in place.
Su señoría, voy a solicitar que estas fianzas se mantengan tal cual.
Should Mr. Sanchez Perez post those bonds,
Y si el señor Sánchez Pérez los puede pagar,
that they be supervised by pretrial release services
solicitaría que se le impongan medidas cautelares
with a GPS monitor level 2.
con un monitor GPS nivel 2.
Your Honor, I would note that
Su señoría, cabe notar
he has a prior federal conviction,
que él ya tiene en su expediente una condena federal
2009,
en el año 2009
for conspiracy to import marijuana into the United States.
por asociación ilícita con el fin de importar marihuana a los Estados Unidos.
He was sentenced to 4 years supervised. It looks like 4 years in federal prison,
Y fue sentenciado a 4 años en la prisión federal,
to be followed by 4 years supervised release.
seguidos por 4 años de libertad bajo medidas cautelares.
At the state level, he has 15 prior felony convictions in the state of Florida.
Y a nivel estatal tiene 15 condenas anteriores por delitos, por felonías en el estado de Florida.
And I'm very concerned based on just the sheer amount of gift cards he was in possession of.
Y me preocupa simplemente por el monto en sí, la cantidad en sí de tarjetas de regalo que poseía, tenía a su haber,
That had been re-encoded with stolen credit card information.
los cuales habían sido recodificados con información proveniente de tarjetas de crédito robadas.
Nothing further.
Y eso sería todo para la fiscalía.
Judge, from what Mr. Sanchez advised me, at this time he is not working.
Señora juez, según me informa el señor Sánchez, en este momento no se encuentra trabajando, no tiene empleo.
He was previously working at a pizzeria place and doing delivery.
Anteriormente trabajaba haciendo entregas para una pizzería
And now he's currently looking for employment.
y ahora está buscando empleo.
He lives in Miami,
Vive en Miami
where he's been living in the same apartment for 5 years now.
y ahí ha estado residiendo en el mismo apartamento durante los últimos 5 años.
Now, he does have family that live in South Florida, but unfortunately, he doesn't have their phone numbers memorized, and he doesn't have his phone and property.
Sí tiene familiares que viven en el sur de Florida, pero lamentablemente no se han memorizado los números de teléfono de esas personas y tampoco tiene acceso a su teléfono y su propiedad.
So he has no way of contacting anyone to post his bond.
Así que no tiene ninguna forma para contactar a nadie que pudiera pagar su fianza.
So I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Sanchez.
De manera que yo voy a solicitar que su señoría tome lo anterior en cuenta a la hora de fijar cuáles van a ser las condiciones de libertad del señor Sánchez.
Right, Mr. Sanchez is before the court today
Bien, el señor Sánchez está ante este tribunal hoy
with, facing allegations that he was in possession of 70 gift cards
con cargos en su contra, los cuales alegan que tenía en su posesión 70 tarjetas de regalo
that was re-encoded with stolen credit card information
las cuales estaban recodificadas con información proveniente de tarjetas de crédito robadas
and with numbers in black marker on the back of the cards
y con números escritos con un marcador negro por la parte posterior de cada tarjeta,
for the zip codes and the PIN numbers.
que especificaban los códigos zip y los pines.
And further, that he had a vehicle that was equipped with an extra drum
También se alega que conducía un vehículo que estaba equipado con un estanque adicional,
to transport fuel.
un estañón para transportar combustible.
Based on that, plus the information that was provided to the court this morning,
Dado todo lo anterior, así como la información que se le ha proporcionado a este tribunal esta mañana,
the court does find probable cause,
consideramos que existen indicios probables de delito
and the court believes that the reasonable bond
y consideramos que una fianza razonable
is $1,000 on each count.
sería de $1,000 para cada cargo.
And as indicated on the probable cause affidavit.
Tal y como se indica en la declaración jurada sobre indicios probables.
Okay, thank you.
Eso sería todo. Gracias.
Sure. Wait, is, no, yeah. Is there anyone else who needs a Spanish interpreter?
Not at Main, Judge.
All right, at any of the other facilities?
Conti is good.
Okay,
Oh, Brown's good, John.
thank you, thank you. All right, Samuel Roberts.
Mr. Roberts is approaching you.
Mr. Roberts, you are before the court today
Yes, ma'am.
for count 1 is grand theft, and count 2 is possession of an anti-shoplifting control device. And the court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Roberts on pre-trial release. First, he does have contact with the system, but he's been clean now for a couple of years. He's 29 years old, been here his whole entire life, and the good thing about it, at this time he's been working at the Dollar Tree for 7 months now. He works there basically full-time, making about $9 an hour. The good news, well, yesterday was his day off. He's scheduled to work tonight. He works the graveyard shift from 12 midnight to 8 a.m. He really wants to be in a position so that he doesn't lose his job. His family depends on him. He lives in Deerfield Beach with his aunt, who he's been staying with, and she's on disability. Judge, right now, from what he advised me, his aunt cannot financially post his bond, and that's why we're asking for him to be released on pre-trial release on this case, Judge.
Where did you say he's employed?
The Dollar Tree. Yes. And he told me he's scheduled to work tonight at midnight to 8 a.m. 8 a.m. in the morning, yeah.
Okay, state.
Your Honor, I'm just checking to see when he was released from state prison. Your Honor, I'm objecting to pretrial or any type of ROR. 2013, resisting a merchant and theft. 2013, grand theft, VOP, 18-month state prison. 2013, grand theft, felony theft, resisting without violence, VOP, 18-month state prison. 2011, theft. 2009, grand theft auto, 364 days county jail. 2008, battery and theft. 2008, theft. 2008, theft, resisting a merchant, resisting without violence. 2008, theft, and he was released from state prison in 2015.
All right, Mr.
Got out of
Roberts.
prison. Oh, sorry.
Mr. Roberts, your standard bonds are going to remain in place, okay? Kennard Wooten,
Come on up, Mr. Wood.
Mr. Wooten, you're before the court for driving while license suspended, and the court does find probable cause.
Judge, I'm going to be contacting Mr. Wooten's family and friends to help post his monetary bond.
Okay, So Mr. Wooten's bond is $750.
I'll call Ebony right when I get out.
DeAndre Calix,
Mr. Khalid? Good morning.
good morning, sir. You are before the court today. Possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a school or park. Count two is possession with intent to sell, deliver, manufacture heroin within 1,000 feet of a specific area. Count three is possession with intent to sell, manufacture alprazolam within 1,000 feet of a school or park. Count four, selling cocaine within 1,000 feet of a school or park. And count five is possession with intent to sell or deliver a scheduled drug. All right. Court does find probable cause.
Judge, I see his bond is $26,000, and I do understand the allegation is serious. However, my understanding, Mr. Police, has a clean record. He's a registered voter here in our community. He's been here his whole entire life. He's 21 years old. He's working and going to school. He works at Publix, where he's been employed for 8 months, making approximately $11.50 an hour. And he goes to Broward College, where he's studying to be a paralegal. Unfortunately, Judge, he's homeless. He does have a mailing address, though, that he can use. His friend that resides in Sunrise. But from what he has advised me, he's basically indigent. So, Judge, I'm asking you to take that into consideration in determining reasonable release conditions for Mr. Calixte.
Your Honor, I was actually going to be saying I have no objection to pretrial level 2, considering one of these offenses a first-degree felony, but he has no priors. He's the registered, and the vehicle that's mentioned here, 2017 Hyundai, he's the registered owner of this vehicle.
Lives in his car.
All right, Mr. Calix, I am going to release you to pretrial supervision. He lives in his car. I don't have an address.
I don't know if it was stated how long he's been homeless.
About 2 months now.
2 months?
Yeah, I had just lost my job, my main job, and that's what resulted in all this.
Don't talk about that.
It's about 2 months.
Judge, he's been homeless for about 2 months.
About 2 months ago, he went to the DHSMD and got a new ID card with a residence in Lauderdale.
He was the driver, he was the owner of the car, because I know there's another.
Yeah, it's the next gentleman on the docket, but he was the passenger. Mr. Calixte is the registered owner of this vehicle.
Judge, I know with this type of charge, I rarely ask for just straight pretrial, but unfortunately, as he is, he's homeless. What you could do, Your Honor, you could actually modify the conditions of pretrial, even impose more restrictions. I know this usual for standard pretrial is basically calling once a week and report once a month. You can have him basically report once a week to keep a tighter tab on Mr. Calixte. I'm just offering different alternatives, Judge.
You put this on recall, Your Honor, because it mentioned, the deputy mentions that they recovered his wallet with cash in it. I'm curious how much cash was in his wallet. I could reach out to the deputy.
If he had any if he had any cash, the jail has already started.
No, I wasn't trying to suggest he has access to it. I'm just saying what's being represented. I mean, someone that's owner of a 2017 vehicle just listed a residency 2 months ago. Now I'm just curious how much cash there is. If If it's a small amount, okay, but if it's a larger amount, then it doesn't really seem, the picture that Mr. Romero's painting doesn't really make as much sense.
Well, if, I'm sure if the officer wanted to add the monetary amount, that's usually part of with the intent to sell if they have a substantial amount of money.
Oh, yeah,
That's
no, no.
usually in the police report.
Understood, but she also, the deputy might not have, and I couldn't expect her to know that issues of his financial means for bond purposes might, be argued at his first appearance.
Okay, I'll put it on recall.
Thank you.
All right, Stanley Francois.
Mr. Francois is the first. Come on up, sir. Your Honor.
Mr. Francois, you're before the court. Count one is possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a school or park. Count two is possession with intent to sell, manufacture, or deliver heroin within 1,000 feet of a school or park. Count three is possession with intent to sell alprazolam within 1,000 feet of a school or park. Count four is possession with intent to sell, deliver cocaine within 1,000 feet of school or park. And count five is possession with intent to sell or deliver a scheduled drug. The court does find probable cause. And then we'll hear in regards to Mr. Francois.
Judge, on Mr. Francois, I'm going to be asking on him for a level 2 GPS. He lives with his mother locally in Deerfield Beach, where she rents, doesn't own a home, and I believe what he informed me is the rent is about $900 per month. Now, his mom does work. She works at a maintenance department, and he really doesn't think she could afford very much. Having said that, Judge, he goes to school full-time studying health services, where from what he advised me, he won, I believe, a grant for first-generation college students. My understanding, Judge, he has limited contact with the criminal justice system. I believe it was maybe about a year ago, in which was driving a cannabis and I believe another drug offense, which I believe he believes it was ultimately dismissed. But Judge, having said that, we're asking for a level 2.
All right, the court will release Mr. Francois to pretrial supervision with the level 2 GPS. Okay. All right, Miller Pierre Louis.
Mr. Louis responded.
All right.
Thank you.
Derek McKnight.
He's approaching, Judge. He's hearing me.
All right, Mr. McKnight is before the court. Count one is video voyeurism. And count two is felony violation of probation, and the court does find probable cause. Mr. McKnight, the count two is a no bond hold, and so he does have court before his division judge, I believe, on Monday at 8:30.
Your
As
Honor.
to count one,
Your Honor, the state is going to be requesting a $15,000 bond. No return to, and I believe this occurred at Sawgrass Mills, so I'd ask that he not return to Sawgrass Mills. I would also ask that the court order that Mr. McKnight not be in possession of any devices or equipment with video recording capability. I would note, in addition to the case he's on probation for, in 2017, Mr. McKnight was convicted of 2 counts of exposure of sexual organs.
Judge, he's working. He works as a host at Miller's Ale House, making about $6.25 plus tip. So, Judge, considering he has a no bond hold, we're asking for $1,000. No objection at this time with the other conditions that the state has recommended.
okay, the court does find probable cause, and at this time, as to count one, the court will impose a $15,000 bond. Mr. McKnight is to have no device, no recording video device, okay?
Linder.
Brian Burton.
He's approaching, Judge.
Okay, hold on a moment. I can't hear anything you said. Yes, yes, thank you. Okay, Mr. Burton is before the court. Count one is possession with intent to sell, manufacture, or deliver cocaine. Count two is resisting officer without violence. Count three is riding a bike with no light. Count four is tampering with or fabricating physical evidence. Count five is possession with intent to sell, manufacture, or deliver cocaine. All right, the court does find probable cause.
Judge, Mr. Burns says no one can afford to post his bond. He's requesting pretrial release.
Okay, state. Yes. Okay.
Your Honor, state would be requesting that the bond be kept in place. He pled out a drug paraphernalia April 3rd and February 28th of this year. Felony cannabis charge 2011. 07 possession of cocaine, 07 possession of cocaine, 03 possession of cocaine, 03 possession of cocaine, 02 possession of cocaine with intent to sell or deliver within 1,000 feet of a place. Could you answer that? Within 1,000 feet of a place of worship. He's had multiple aliases. He's been to state prison. I see on at least 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 different cases. Hello?
All right, at this time, the court, I am going to leave the standard bonds in place as to all the counts, okay? Martavis, I'm sorry, we can go back to DeAndre Calixt.
Mr. Felix, come on. Mr. Felix, come on, please.
Started a couple months ago to a resident in Lauderdale. Okay, I gotta go though, this case is back on. All right, thanks. Your Honor, I can advise the court, I just got off the phone with Deputy Petrovsky. I spoke with her sergeant, who was also there, investigated this matter. What they advised me, there's nothing in his car to indicate that he lives in his car. There's not clothes, no kind of, there's just nothing there to indicate he is actually living in his car.
Okay.
Judge, I know the state initially said they were contacting and find out how much money is. I don't know if they ever got the answer to that question, that they were asked the court permission to call for that purpose.
It was over $100, Your Honor, but I received, and Mr. Romero can smirk all he wants. There's additional information, Your Honor, that I think is relevant for the court to consider on top of everything.
Well, here's the issue. The other co-defendant has no priors. I took all of that into consideration. I put him on level 2 GPS. That was my intention, which I asked, which is why we started talking about where does Mr. Calix live, and this is charged with intent to sell 3 different types of drugs. I'm not just going to put him on standard pretrial release. So where does he live? And so at this point in time, I'm gonna leave the standard bonds in place, and if there's a place where he can you know, like a James Club or some other place that he can go to, you know, I'll be happy to consider that.
Judge, would you consider that, he's also, I believe, in the same position except for the residence part.
Right.
Would you consider putting a level 2? I know he's signed up with the public defender, he's gonna have an early representation unit attorney assigned to his case. At least that would be in place, so if that attorney can find a place, there's already court order, and it could speed up the process, so would your honor then consider at this time level 2?
Well,
Because pretrial still has to verify.
that's right, and that was the court's intention, but he has no address. And then the problem that I've seen before, I think maybe once or twice before, we asked for that to happen, and then we have the persons going back and forth because, you know, they have that order out there, and then, you know, no place for them to be.
Well, I
So,
can tell you, Your Honor, if you were to place him on GPS level 2, he's not gonna come back before the court, frankly, on a second look, because there's a first-degree felony. He's not eligible for a second look. I would just ask the court, if pretrial can make a note, I don't have an objection to pretrial level 2. The defense is asking for pretrial level 2. So even if they can't verify, pretrial should not bring it back to this division, because this is also based on the request of the defense.
okay. All right, well, then I'll grant the level 2, and so we'll make the change. You know, it's RR to pretrial and level 2 GPS. Okay, Martavis Harvard.
Mr. Harvard, come on up, please.
All right, Mr. Harvard is before the court. Count 1 is possession with intent to sell, deliver, or manufacture cocaine. Counts 2 through 5 are felony violation of probation. The court does find probable cause. Mr. Harvard does have court on Monday at 8:30 before his division judge on the felony, on the VOP matters. And then his bond on count 1 is $2,500. Good luck, sir. James Hilton.
He's here at main judge.
Mr. Hilton is before the court. Count 1 is possession of cocaine. Count 2 is possession of cannabis, 20 grams or less, and the court does find probable cause.
Judge, Mr. Milton's requesting that the court consider releasing him on pre-trial release. Now, he does have prior contact, but he said it's been about 2 years, and what he informed me, he's never gone to prison. He's 31 years old, been here his whole entire life. He works off and on doing landscaping, and he lives in Hallandale Beach with his mother. His mother drives school buses for a living, and from what he advised me, she financially at this time can't post his bond, so that's why we're asking for pre-trial release on Mr. Ellen's behalf.
I don't have an objection, Judge.
All right, so Mr. Hilton will be released to pretrial supervision. Sir, that's also going to include random drug testing. Okay? Okay, so you need to report to pretrial supervision. If you don't get out in time, they close at 4:30, and today's Friday. They're not open on weekends. So then you must report first thing Monday morning. Failure to do so, a warrant will be issued for your arrest. Okay? All right, sir. Thank you. Jadunanan is not here today,
Yeah,
right?
the only thing Your Honor, I don't know if the court might be inclined to put a note maybe for Judge Lopane that, you know, he might still be on a Baker Act,
Okay.
so no action's taken. And I'll call into the ASA that's here this weekend to let them know.
He does? Oh, that's
Yeah,
right, he does.
Friday morning. Or if you find out he's going to do this weekend, then just unless he's back. Even if he's back, it probably should be reset for Monday first.
Okay. All right, Avery Lawrence.
Agum, no problem.
All right, Mr. Lawrence is before the court. Count 1 is grand theft. Count 2 is false ID given to a law enforcement officer. Count 3 is a felony capias. This is on a felony petty theft charge. There is a no bond hold as to that count 3. The court does find probable cause. I'm not sure what this date says that he's going to court. But looks like here's,
Looks like
should it have been
Monday.
today? Oh, Yeah. It's okay on Monday, so he'll be before his division judge on Monday.
Hey, so ask him. They
I just
told me
asked-
did they move it from the 16th to the 13th? Cause I went to court yesterday. They told me on the 16th.
All right, so you're gonna be, they moved it from the 16th to the 13th, so that's Monday. You'll be in court on Monday. That's correct.
All right.
Okay?
Okay.
All right, sir.
Thank you.
You're welcome. Count one, the bond is in place, remains in place. Jared Clark,
Judge, I've been advised he was staying in court.
he's in court, okay? And then Nakayun Holsey,
Confi, Your Honor.
all right, good morning, sir. This is a change of charge?
Yes, Your Honor, it's, I can advise the court. When Mr. Hosley first came before Judge Evans for first appearance, it was booked as a robbery with a weapon. I can advise the court. It's still basically a lateral change of charge because it was a robbery with a weapon, but now it's an attempted robbery with a firearm or deadly weapon. If you'd like, I can print the court a copy of the original warrant. It is clear on its face that this was an attempt. It specifically states in the warrant, robbery with a weapon, did unlawfully attempt to commit robbery by attempting to take from the person or custody of Kenesha Wallace certain property, et cetera, et cetera.
Okay.
Judge Evans set a bond on this count of $40,000, no victim contact, no return. I'd ask that the court set the bond back at $40,000.
Okay,
Mr. Halsey has a no bond hold for violation of probation on count 3.
all right.
So he'll need to go in front of his division judge.
So, Mr. Holsey, you understand what was just said? It's the same charge that you came before, the same allegations that you came before the court, but at that time, it did not say attempted robbery, which is what it is, okay? So, your bond, is still $40,000. The no victim contact order is still in place and no return, okay?
So I do have questions though.
Okay?
I was told that the state had 33 days or something like that to file charges. Are those charges filed or is it still?
You know,
No, they're filed, that's why we're here, because
They've
there was
been
a
filed.
technical change of charge.
They've been filed.
Okay, and so my next question was that a public defender came and talked to me and they sent me to court yesterday and the public defender said that she's not my public defender anymore. And also, I was looking for, I'm looking for the discovery because the alleged victim, which is my cousin, they never had went to a hospital, got any type of stitches.
Don't discuss
Mr.
the facts
Halsey,
of the
don't
case.
talk about your case, okay? You talk about your case with your attorney. And I don't know if it was because of a conflict, if there's gonna be a special public defender but please, just talk to your attorneys about.
I don't see
can
any.
advise you-
Okay.
I can advise you, so Mr. Halsey's aware.
Yes.
Yeah, there's nothing in Odyssey to indicate that the public defender is not representing him. He
Okay.
was arraigned by Judge Merrigan yesterday, that's why we reset him.
Okay,
And Mr. Reedy can confirm this, in Odyssey, the state's discovery submission was e-filed yesterday.
okay.
Okay.
So they sent the information to the discovery to your attorney yesterday, so they'll be able to provide you with a copy, okay?
Can you tell me what the court date is on the 13th? What's that for?
I don't know what it is for.
I can tell you, it's
Okay.
one of those unnecessary things. He was on our docket today, so pursuant to the AO, because he
Right.
was here on a capias, he had to be scheduled for a status in front of his judge.
Okay.
I imagine nothing's gonna happen at that hearing.
Okay. All right, sir, good luck.
And your public defender is Kristen Collins, sir.
They have it as,
So it's a new public defender.
I don't know, but that's what my records show, that's who's representing you now. And maybe so, yeah, it might have been,
they show as a
she might have been reassigned on the 9th, which would have been yesterday.
All right, Morel Auxiliaire,
You guys can figure it out, I'm sure.
you moved Mr. Auxiliaire to the PM. Okay. Was is he in the room? Because I see two persons sitting there. Gano Hicks,
Judge,
auxiliary is reset to PM, I'm told.
Yes.
And
Yes,
then,
Judge.
and then the next
Mr.
person
Gano
is
Hicks is
Gano
Conti.
Hicks, is Conti. And then Gano Hicks?
Yes, ma'am. Sorry about
Okay.
that.
All right, Mr. Hicks.
How you doing, Your Honor? How you doing?
I am doing well, sir. You're before the court on 3 additional charges. Count 4 is grand theft. Count 5 is false owner info for pawn items. And count 6 is dealing in stolen property. Okay? The court does find probable cause. And does, Mr. Hicks is in custody on other counts?
He's got a domestic violence battery. He posted the $1,500 bond. He's got 2 $500 bonds on 2 counts of failure to comply with the registration law.
Okay.
Your Honor, considering that the alleged victim in this case is the same victim as that domestic violence battery, I'm requesting that the court leave the bonds in place.
Okay. All right, so Mr. Yes, Mr. Reedy.
No, that's fine.
Hold on just a moment. Okay. Sir, so your bonds on 4, 5, and 6, it'll be $1,000 on each count, okay?
Your Honor.
Yes, sir.
Ma'am, I was like last week from graduating from the class I'm taking at the VA. I am a veteran. I want to know if it's possible I can get my case. I'm on 5 different psychiatric medications, and I want to kind of get my case turned over to the VA court. Please.
I
I
don't,
think the first 3 counts is
what are the first 3 counts?
domestic violence battery and failure to
Oh,
register.
the based on the nature of some of your charges, sir, you won't qualify for the VA court, okay?
Even
All
though
right,
I'm
sir,
on discharge.
there are requirements, and I'm telling you that there are some things on the charges that prevent you from being in a VA court. It's not just that you're a veteran. There are other considerations. Talk to your attorney more about that, okay? All right, Nicholas,
Can I get a speedy trial?
talk to your attorney about that, okay?
Okay, thank you, ma'am.
All right, Daniel Nicholas?
No problem.
All right. We haven't heard from Mr. Lewis, is that correct?
That is correct.
All right, so Ms. Nicholas, you are last on the docket. We've waited 2 hours now, so we're going to proceed on your case, ma'am. All right?
Okay.
So you are before the court for petty theft. Count 2 is possession of controlled substance without a prescription. And count 3 is neglect child without great bodily harm. I do find probable cause as to those 3 counts. And if you want to be heard in regards to setting your bond, you can talk about that, but not talk about the case. And then I will hear from the state attorney's office.
Okay.
Judge, I don't know what kind of financial bond Ms. Nichols is going to be able to make. I have a feeling it's not much.
Okay?
I'd ask the court to consider a pretrial release for Ms. Nichols.
Your Honor, I'm just noting, and I'm asking for a $2,500 bond on 3, no victim contact. She has a pending grand theft right now. She pled out 2015 domestic violence culpable negligence and a theft in 2015.
Great. Ms. Nicholas, at this time, the court is going to impose a $1,000 bond on count 3. You have a $1,000 bond on count 2 and a $25 bond on count 1. Okay? Good luck, ma'am.
All right, I'll keep trying to reach Mr. Lewis for you, Ms. Nicholas.
Okay, thank you.
Yes.
Judge?
Yes.
There's 2 gentlemen here that the deputies were told to bring. They're on page 10 of the docket, and both of them are for violation of probation.
Yes, do we still have that paperwork? Apparently, Ms. Judge Alspector is out today, and so they sent them,
Sure. Okay.
I want to just, they're right there, right
They're-
now. If you just want to advise them what
They're-
they're here
they're-
for, you
they're
can
here.
just sign off on the paperwork this afternoon.
yes, we had the paperwork, we just
Okay,
didn't have,
great, yeah.
they took it back?
And that's why I was saying, and that's, no, Your Honor, that's why I was saying, if you just want to, if we can just advise them what they're being held
But do I
on.
have that information?
We can get a copy of the doc, is it a copy of the document? They're both on warrants.
Okay. I'll-
She doesn't have the fines.
I-
Shirley took the paperwork, and she's gonna put them on the document tomorrow, so they can be sent.
No, she's gonna put him on the, she's gonna put him on the docket for this was it for tomorrow? Oh.
Never mind, I was gonna.
All right, so what happened is, the paperwork was here this morning. We didn't know that these two gentlemen were going to be here, so the clerk took the paperwork back because it was not the docket. So they'll be on the docket tomorrow, all right? So I don't have the paperwork, otherwise I would have handled it, but they did take the paperwork from me. All right? Okay.
Thank you, Your Honor.
All right, you're welcome. So.
Mr. Topper, same thing with you,
So,
okay, sir? Mr.
All right. Oh.
And here's Topper, same thing.
All right, so Mr. Topper, in case you didn't hear what I said to the other gentleman, your regular judge is out today, and they did ask for me to cover, but they're violation of probation. And we didn't know that you were on the docket, so the clerk has taken the paperwork from me, so I wouldn't have paperwork to sign off today. So they'll bring you back tomorrow so that your paperwork will be here when you're here for your VOP to be addressed, okay? All right, I think we're at the end of the docket. Thank you.
Just